Hello, and thanks for joining us for Law in the Library. I'm your host, Robert Reeders. The Alachua County Library District and Three Rivers Legal Services have partnered for over 10 years on the Law in the Library series. Three Rivers Legal Services is an LSC that provides free legal services since 1978. They have offices in Gainesville, Fernandina Beach, Jacksonville, and Lake City, and provide assistance on domestic violence and family law, housing and landlord-tenant issues, foreclosure defense, money and debt, veterans issues, record sealing and expungement, elder law, hurricane disaster assistance, and public benefits. Their telephone number is 352-372-0519, and their website is https://www.trls.org. Today's presentation is on Medicaid Budget Waiver Eligibility and Enrollment, presented by Angela Caldwell, the Public Benefits Project Manager at Three Rivers Legal Services. Ms. Caldwell earned her law degree from the Shepherd Broad College of Law at Nova Southeast University, and her areas of focus include disability law, elder justice health law, administrative law, and veterans law. And now, Ms. Caldwell, I'll turn over to you.
Thank you, Robert. So today I'm going to be talking about Medicaid waiver eligibility and the fair hearing process. For accessibility purposes, closed captions, the C button is on the bottom of the screen. A little bit about Three Rivers Legal Services. Our mission at Three Rivers Legal Services is a nonprofit law firm dedicated to the provision of quality legal assistance to the poor, abused, disabled, and elderly, as Robert said, and empowerment through preventative legal education. Our background at Three Rivers Legal Services, as a nonprofit law firm, we are dedicated to providing free legal help, and we have offices in Gainesville, Jacksonville, Lake City, and Fernandina Beach, Florida. We're dedicated to the provision of quality legal assistance to the poor, abused, disabled, and elderly, and to empowerment through preventative legal education, as I said before. We provide free civil legal help to low-income families in 17 counties, including the following areas. We cover Alachua, Baker, Bradford, Clay, Columbia, Dixie, Duval, Gilchrist, Hamilton, Lafayette, Levy, Madison, Nassau, St. John's, Suwannee, Taylor, and Union counties in North Florida. And we also provide services in the cities of Bronson, Chiefland, Cross City, Fernandina Beach, Gainesville, Green Cove Springs, Jacksonville, Jasper, Lake Butler, Lake City, Live Oak, McClenny, Madison, Mayo, Orange Park, Perry, St. Augustine, Stark, Trenton, and Yulee. All of our offices can be reached by calling our toll-free legal helpline at 866-256-8091. We provide legal services in the areas of housing, family law and domestic violence prevention, elder law, education law, public benefits and veterans law, and estate planning. We also work closely with many pro bono lawyers and law firms to expand our ability to provide free legal advice and representation to eligible people in Northeast and North Central Florida. The two waivers I'm going to talk about today, as far as eligibility, are the iBudget waiver and the LTC, which is the long-term care waiver. Both of these are waivers that are administered through the state of Florida's Medicaid program. And I'm going to start with the iBudget waiver eligibility guidelines. So the Agency for Persons with Disabilities, or APD, operate the Home and Community-Based Services iBudget Medicaid waiver in the state of Florida. So the Agency for Persons with Disabilities and the overall Medicaid is a sister, a sister organization to ACA in the state of Florida, and ACA has given APD the power to oversee the iBudget waiver process and services. So in order to be eligible to participate in the iBudget waiver, an applicant must have been determined to have a qualifying developmental disability or be at high risk of a developmental disability as defined by statute. A developmental disability means a disorder or syndrome that's attributable to one of the following conditions: intellectual disability, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermott syndrome, or Prader-Willi syndrome. And one of these syndromes or developmental disabilities had to have manifested before the age of 18, and they have to be constitute a substantial handicap that can reasonably be expected to continue indefinitely. Additionally, applicants to the iBudget must be at least 3 years of age, a resident of and domiciled in the state of Florida, and have a confirmed diagnosis of one of the aforementioned developmental disabilities, as well as meet a level of care requirement. The full eligibility guidelines can be found in Rule 65G-4.014 and 4.015 of the Florida Administrative Code. The level of care requirement that I just discussed in the last bullet point, I just wanted to say a little bit more about. So it's mandatory that a determination is made that without iBudget waiver services, that the applicant would otherwise require a level of care that's furnished in a hospital, a nursing home, or an intermediate care facility for people with intellectual disabilities. Now I'm going to talk a little bit about the eligibility guidelines for our long-term care waiver in the state of Florida. So to be eligible for the long-term care waiver, an individual has to be one of the following: 65 years of age or older and need a nursing facility level of care, or 18 years of age or older and eligible for Medicaid by reason of disability and need a nursing facility level of care, or 18 years of age or older with a diagnosis of cystic fibrosis and have a hospital level of care. And the full eligibility guidelines can be found in Rule 59G-13 of the Florida Administrative Code. So for the iBudget waiver and for the long-term care waiver, the fair hearing process is similar, but the organizations, the offices of that are overseeing the fair hearing process are different for each one. So the Office of Fair Hearings, OFH, is part of the Agency for Healthcare Administration, ACA. OFH employs hearing officers who conduct hearings, administrative hearings, in cases affecting Medicaid fee-for-service and managed care recipients. And then I've provided the OFH website, which is flmedicaidmanagedcare.com/home/Medicaid Fair Hearing. So the Office of Fair Hearing oversees the LTC waiver fair hearings. And then we have the Office of Appeal Hearings, OAH, and it's part of the Florida Department of Children and Families Office of Inspector General. OAH employs full-time hearing officers who conduct hearings in cases where a state agency such as the Agency for Persons with Disabilities, APD, or the Department of Children and Families, DCF, make a decision which unfavorably affects a person's rights or benefits. So the Office of Appeal Hearings doesn't only oversee the fair hearings that have to do with the iBudget waiver. They also oversee hearings that pertain to Department of Children and Families. But for our purposes today, the Office of Appeal Hearings oversees any fair hearing that's requested by someone that has been denied eligibility for the iBudget waiver or had any service denied, reduced, or terminated as part of the iBudget waiver. And then I provide OAH's website, which is myflfamilies.com/about/us/inspector/general/appeals/hearings/. This is just the contact information for the Office of Fair Hearings. So when you request a Medicaid fair hearing, or a long-term care waiver, fair hearing through ACA, you're going to contact the Agency for Healthcare Administration's Medicaid Hearing Unit. I provide the address, the phone number, the fax, and the email address. I usually use the email address to send any request for fair hearing that's related to the long-term care waiver. OFH's contact information for obtaining information from ACA regarding a Medicaid fair hearing request is the following. So here's again the address for that, telephone number, fax, and email address. These would all pertain to, like I said, the long-term care waiver. And then here's the Office of Appeal Hearings contact information. So any request for fair hearing pertaining to the iBudget waiver, you would use this contact information for the Office of Appeal Hearings, and I provide the address again, telephone number, fax, and email address. And I usually always use the email address. So next I'm going to talk about kind of the procedurally what happens during a fair hearing, which is very similar to whether you're in the Office of Fair Hearings or the Office of Appeal Hearings. The process and the words to know are still the same. They can be used interchangeably. So I've provided a few of the buzzwords that you're going to run into in one of these administrative hearings here. First is the petitioner, and that's the person that's requesting the appeal, the person whose services are being reduced or denied. The respondent is going to be the agency or the organization that made that determination to either reduce or deny the petitioner's services. An exhibit is a piece or set of evidence in a hearing, usually a document, could be a lot of things though. It could be a document, it could be a photo, it could be a business record. And exhibits are any evidence that you're going to want the administrative hearing officer to take into account during the fair hearing. You're going to want to submit as an exhibit for the hearing officer to have a copy of and look at during the fair hearing and then after when they're making their final determination. So the hearing officer is the presiding officer or judge at the administrative fair hearing, and the burden of proof is the responsibility of a specific party, here either the petitioner or the respondent, to use the evidence to prove to the court and the administrative law judge what the party believes the outcome should be, and it must be proven by a preponderance of the evidence, and the preponderance of the evidence just means more likely than not. So that's the legal standard. It has to be more likely than not, over 50%. That's what you have to prove to the hearing officer to prevail in an administrative fair hearing. So the whole process of an administrative fair hearing starts usually with a determination and a notice. So ACA, APD, managed care companies, and others must send you a written notice whenever they deny, reduce, or terminate your request for supports or services. Verbal notice is not enough. Don't accept verbal notice or other informal notice. Always request a formal notice in writing. So look for three things in a notice. What is being denied or reduced? What's the justification that's given in the notice for the denial or the reduction? And what are your appeal rights and instructions? This is very important, this third one, because any notice with a determination should tell you exactly who you should be contacting if you want to file an appeal or you want a fair hearing, and the timeline that you have to do that. So follow all the instructions that are given in the notice. Like I said, the deadline for requesting an appeal varies depending on the agency, but it should always be clearly stated in the notice that you receive. So it might be 30 days, it might be 10 days. You really have to look at those notices and make sure that if you are thinking about requesting a fair hearing, that you do it within the given number of days that it states in the notice. And here's a tip. So be sure to make it clear if you want to continue to receive the services if they've been denied, or I'm sorry, not if they've been denied, they've been reduced or terminated, pending the outcome of your appeal. So the deadline for requesting to continue to receive services may be different than the deadline to request an appeal, but it should be also clearly stated in the notice. Sometimes you must request continued services immediately following any adverse action. So the other thing I always tip I give to people if they're going to request an appeal is to make the request in writing. So although you can call and request an administrative appeal, I always suggest that you follow up in writing just to have a document trail of your request and something that's time-stamped. So you can make a request by email, fax, or mail, and you should save a dated copy of the request in case it comes into question or the agency says they didn't receive it timely. You can go back and say, no, I sent it on X date, which was within the timeline that I had to request an appeal per the notice. Medicaid managed care plans and the Office of Fair Hearings utilize verbal requests for fair hearings. Like I said, if you don't follow up in writing, write down the date and time and the name of the staff that you spoke to when you made your verbal request for the fair hearing. Key differences when requesting an appeal. There are key differences in the appeals process for each agency and managed care company. When appealing a notice of adverse benefit determination from a Medicaid managed care company or long-term care LTC waiver, you must submit a plan appeal and receive a notice of plan appeal resolution before you can request a fair hearing, which is conducted by the Office of Fair Hearings. So that this all goes to say with any LTC waiver recipient who has had an adverse action, you have to exhaust the internal plan appeal process before you move on to requesting an administrative fair hearing. When appealing a notice of outcome from EQ Health Solutions, you can request a reconsideration, but it's not mandatory. You can request a fair hearing without requesting a reconsideration. The fair hearing, again, is conducted by the Office of Fair Hearings. And when appealing a notice from the Agency for Persons with Disabilities, there is no reconsideration or secondary review. So if you're an iBudget waiver recipient, you would go straight to requesting a fair hearing if there's been an adverse action. And the request for fair hearing will be submitted to APD directly, and the fair hearing is conducted again by the Office of Appeal Hearings. So documentation and evidence submission. Once you've requested a fair hearing, you should get a scheduling order from either OFH or OAH stating when and where the hearing will be held, along with directions for submitting evidence exhibits prior to the fair hearing. In order to determine what documentation and evidence you may want to submit in the hearing office to support your case, you'll need to research the law and rules that affect your case. Usually in the notice, that's where I start. Usually the notice, if the determination has been made pursuant to any Florida Administrative Code rules, statutes, they will likely be in the notice, and that would be the first place that I would start doing any of this research. You also want to speak with witnesses and gather additional evidence to support your position and arguments at fair hearing. So once you have gotten a good idea of what laws and rules are applicable to the issue in your case, you want to determine what sort of evidence you have, what sort of witnesses might be able to speak to that issue to support your position. Evidence and witnesses. So evidence can include, I spoke to this just a little bit ago, anything. Exhibits can really be anything: medical records, school records, letters of medical necessity, letters of support from family, friends, professionals, or provider notes, um, pictures, anything that helps to support your position in a fair hearing, that evidence can be submitted. Witnesses can be anyone with specific knowledge about the subject of the fair hearing, and may include your physician, a provider, a case manager, family members, really anyone that can speak to the issue and support your position. You want to prepare your testimony and talk to your witnesses about their testimony early. So because all of the decisions are in administrative fair hearings are guided by laws, rules, or policies, like I said, they should be in any denial notice, which ones were used to make the determination. You want to look those up and get an understanding of why the determination was made using those laws, rules, or policies, and try to foreshadow what the respondent or the agency's arguments are going to be so that you can rebut those when you get to the fair hearing. You may request additional information or documentation from the agency through the discovery process, which I won't go into in depth here, but you should just know that if there's information that you think that the agency might have, or that you don't have, or that you have additional questions that you would like the agency to answer, you can engage in the discovery process and try to obtain that additional information before the fair hearing. And if you need more time to prepare for your fair hearing, you can request a continuance from the hearing officer via email, but you want to be sure that you copy opposing counsel. So that would be counsel for the agency anytime you request a continuance. And in order to request a continuance, you would file a motion for continuance. And a continuance is what a hearing officer can grant to delay the proceedings and give a new scheduling date. You must communicate with the respondent, the agency's representative, or lawyer prior to requesting the continuance from the hearing officer to ask if they agree with your request for continuance, or if they disagree and why they disagree. Your request for continuance to the hearing officer must include a conferral statement. So when you go to make the request, usually an email form to the hearing officer, you're going to copy opposing counsel, and you're going to include in the body that you're requesting a continuance for X reason. You spoke with the respondent's attorney and whether or not they have an objection, and if they have an objection, why. A conferral statement is the statement to the hearing officer that you contacted the respondent's representative to get their input on the request for the continuance before it was requested. So here's an example. I emailed the respondent's representative and they do not object to the continuance. So presenting your case. All witnesses will be sworn in prior to the fair hearing commencing. Both parties will then give opening statements summarizing their view of the case, facts, and issues before the hearing officer. So usually administrative hearings for both OFH and OAH are conducted over the telephone on recorded lines. So once everybody that's supposed to be getting on the recorded line at the time of the fair hearing is on the line, the hearing officer will then swear all of the witnesses in together at the outset before any testimony is taken or any statements are given by either of the parties. So once that's been done and the opening statements have been given, whichever party is assigned the burden of proof for the fair hearing will present their case first. So each side will be able to call witnesses, elicit testimony, offer documents into evidence, and cross-examine the other party's witnesses. So if it's been for example, an eligibility determination by APD that someone is requesting a fair hearing over, the petitioner would give their case in chief first, because they would have the burden of proving why they should have been given eligibility, and why APD made the wrong decision. The hearing officer will also get a chance to ask any additional questions of the witnesses that they may feel are needed for clarification of the issues. This is usually, it can be done at any point in time. The hearing officer can ask a question during a fair hearing, but usually a hearing officer, in my experience, will wait until the end, until both sides are given a chance to ask all of their questions from all of the witnesses, and they'll hold their questions till the end, and then just ask all of the questions at once. However, like there may be a situation where you have an expert that you've asked to call at a specific time during the fair hearing, so that they don't, if it's a multi-day fair hearing, have to show up for every single day of the fair hearing. For those kinds of witnesses, of course, the hearing officer will probably ask any additional questions that they have after both sides are given a chance to ask their questions. And then the hearing officer can, once everybody's, asked all of their questions, dismiss that expert witness for purposes of the fair hearing, so that they can go back and, see their clients and get back to their work. So you should plan your arguments prior to your fair hearing and start by calling witnesses that will bolster your strongest arguments. Make sure that all the evidence you want the hearing officer to consider is properly offered and accepted into evidence at the fair hearing. So these are your exhibits. It's okay to ask for a break to collect your thoughts or slow down if you elicit testimony you weren't prepared for. And when respondent is presenting their case, you may use objections and state them clearly on the record. I try to tell people that are, pro se, they're representing themselves, or, they're representing their child or their loved one, don't get too wrapped up in objections. Objections can preserve certain issues for appeal, but they're not a reason to be stressed out. Research the most used ones prior to the fair hearing relevance, so that you're able to use them if needed. So the procedure of fair hearings and what to expect. Like I said, the hearing will be usually telephonic. The hearing will be telephonic for Office of Fair Hearings, and it could be in person or telephonic for the Office of Appeal hearings. If you want it to be in person, you do have to explicitly request it be held in person. And the hearing officer, the petitioner or the representative, agency area staff, and potentially an agency attorney will be present at a fair hearing. Approach the hearing and your arguments from a logical and rational, not an emotional standpoint. So you want to lay out the series of events, the facts, the reasoning in a very logical way, and you're bringing the hearing officer along with you, so that they can understand why you're making the argument, what your basis of the argument is, and you're trying to get them to come along in a very logical fact pattern. Let the hearing officer guide the proceedings, but don't be afraid to speak up. So you can use objections, you can ask for a break if you need one, really for any reason. The hearing officer will, if you're in the middle of or one of the parties is in the middle of a line of questioning, may just say, let's finish this line of questioning and then let's take a break. But they're usually very laid back as it comes to, if anybody needs a break, allowing that to happen. And requesting accommodations. So contact OAH or OFH by phone or email to request an accommodation for your hearing if you need one. Some examples of accommodations might include an amplified speaker or a translator if English isn't your first language, you should make the request for an accommodation as early as possible, but at least 7 days prior to the hearing date found in the scheduling order. What happens next? So both sides will give once, all of the witnesses have been called and all the questions have been asked, both sides have gotten a chance to question the other side's witnesses. Then you're going to both of the sides will give closing statements. So the hearing officer may allow for proposed orders to be written and submitted at a later date, or they may just say, I just want to receive closing arguments, and once I take everything into account and the exhibits, I will make a final written order. So if the hearing officer allows for proposed final orders from both sides, usually this is when both sides are represented by attorneys, they'll give a date that the proposed final orders have to be submitted by. And once they are submitted, will be taken under consideration along with everything that the hearing officer heard at the fair hearing, and then they will issue a final written order. This can take anywhere from a few weeks to, I've seen it take a few months. Read the final order carefully when you get it to determine what has been affirmed or what has been denied. So appeals. So if you get an unfavorable final order in the administrative fair hearing, you do have the ability to appeal that to state court. But an appeal has to be filed within 30 days of any final order. And you can file in either the district court of appeals where the agency is located, and that's the first district for Tallahassee for either ACA or APD, or the district of where the petitioner resides. So usually I would say more times than not would file in the first district. But you really have to take into account what the issue is and what the courts, the district court opinions have been on the issue, if there have been any, to determine which district might be more favorable to file the appeal in. Appeals have to be based on legal or factual errors contained in the final order that would, if they would have been made correctly, would have impacted the decision that was made. So you can only appeal issues raised during the hearing, and the clerk of courts in the district courts can be really valuable and helpful if you're trying to navigate the appeal process. And that's all of the information I have for today. This is just a quick overview of the administrative hearing process. And just remember that administrative hearings are meant to accommodate non-lawyers. However, you will need an attorney for an appeal to the state court. The key is for good preparation and organization, and try not to let yourself be intimidated by the process. Just focus on the issue that you're appealing and what's going to lead you to your favorable outcome.
All right. I want to thank you so much for that great information, and want to thank our audience for attending today's presentation. Our next Law in the Library episode will premiere on Wednesday, April 9th at 5:30. And as a reminder, previous episodes of Law in the Library are available on the Alachua County Library District's website at www.aclib.us/law-library. And I want to say thank you all very much and hope you have a great day.